A land patent is a legal document issued by a government that grants an individual the original ownership of a piece of land, transferring it from public to private ownership. A land patent is a form of letters patent assigning official ownership of a particular tract of land that has gone through various legally prescribed processes like surveying and documentation, followed by the letters signing, sealing, and publishing in public records made by a sovereign entity. It represents the highest evidence of title and was historically used to transfer public land to settlers, particularly during the westward expansion of the United States, notes Gary C. Dale, attorney at law and acre value. Unlike a deed, which transfers property between private parties, a land patent is the foundational document that establishes the initial private ownership from the sovereign power, say, the Press Democrat and U.S. legal forms. While land patents are still issued by governments to indicate property is privately held, they are also often used by so-called sovereign citizens and similar groups. Land patents are the right, title, and interest to a defined area. It is usually granted by a central, federal, or state government to an individual, partnership, trust, or private company. The land patent is not to be confused with a land grant. Patented lands may be lands that had been granted by a sovereign authority in return for services rendered or accompanying a title or otherwise bestowed gratis, or they may be lands privately purchased by a government, individual, or legal entity from their prior owners. Patent is both a process and a term. As a process, it is somewhat parallel to gaining a patent for intellectual property, including the steps of uniquely defining the property at issue, filing, processing, and granting. Unlike intellectual property patents, which have time limits, a land patent is permanent. A land patent, known in law as letters patent, typically issues to the original grantee and their heirs and assigns in perpetuity. The patent serves as the supreme title to the land, as it confirms that all evidence of title existing before its issuance date has been reviewed by the sovereign authority under which it was sealed and is therefore irrefutable. Consequently, the land patent legally becomes the title to the land described within its boundaries. While the irrefutability of counterclaims is relative in practice, the granting of a patent establishes the permanence of title. In the United States, all claims of land ownership can be traced back to a land patent, first title deed, or similar document regarding land previously owned by France, Spain, the United Kingdom, Mexico, the Kingdom of Hawaii, Russia, or Native Americans. Other terms for the certificate that grants such rights include first title deed and final certificate. Land in the United States of America was acquired by claim, seizure, annexation, purchase, treaty, or war from France, Great Britain, the Kingdom of Hawaii, Mexico, Russia, Spain, and the Native American peoples. As England began to colonize America, the Crown made large grants of territory to individuals and companies. In turn, the companies and colonial governors later made smaller grants of land based on actual surveys of the land. Therefore, in colonial America along Atlantic seaboard, a link was established between surveying a land tract and its patenting as private property. Numerous other land patents were granted by the Crown for lands purchased by private individuals from Native American tribes. Many original colonies' land patents came from the respective controlling country, such as England. Most of these patents were granted permanently and remain in effect to this day. The U.S. government upholds these patents through treaty law, and like all land patents, they are immutable and cannot be altered. Many early land patents granted by Native peoples were disputed, sometimes leading to legal challenges, due to differing interpretations of private property and ownership between these groups. Indigenous Americans typically viewed land and its resources as communal property, supported by oral traditions. In contrast, individuals from Western Europe held more defined and limited perspectives on property, its transfer, and its resolution within a system governed by written laws, crown authority, officials, courts, and permanent documentation. After the American Revolution and the ratification of the U.S. Constitution, the U.S. Treasury Department was placed in charge of managing all public lands. In 1812, the United States General Land Office was created to assume that duty. In accordance with specific acts of Congress and authorized by the U.S. President, the General Land Office issued over 2 million land grants known as land patents. These patents transferred the title of particular parcels of public land from the nation to private entities, such as individuals or private companies. Some of the granted land had associated survey or other expenses. Patentees could pay these fees in cash, homestead a claim, or acquire ownership through various donation acts passed by Congress to transfer public lands to private hands. Regardless of the method, the General Land Office adhered to a two-step process when granting a patent. Initially, the private claimant visited the land office in the land district where the public land was situated. The claimant completed entry papers to designate the public land, and the land office register verified the availability of the claimed land by checking the local registrar records. The receiver collected the claimant's payment, as even homesteaders were required to pay administrative fees. Subsequently, the district land office register and receiver forwarded the documentation to the General Land Office in Washington. This office conducted a thorough review to ensure the accuracy of the claim, the land's availability, and the payment method. Ultimately, the General Land Office issued a land patent for the public land in question and forwarded it to the President for his signature. The first U.S. land patent was issued on March 4, 1788, to John Martin. That patent reserves to the United States 1/3 of all gold, silver, lead, and copper within the claimed land. Original title. A land patent is the highest form of title, representing the first transfer of land ownership from the government to a private entity. An original title can refer to a vehicle title or a property title, but both are legal documents proving ownership. A vehicle title lists identifying information like the VIN, make, model, year, color, owner's name and address, and lien holder details. A property title search provides a history of ownership and includes documents like deeds, mortgages, easements, and liens, often summarized in an abstract of title. Property title. Chain of title, a record of all previous owners and transactions. Deeds. Documents transferring ownership from one party to another. Mortgages. Details of any outstanding loans on the property. Liens. Claims against the property, such as from unpaid taxes or judgments. Easements. The right to use a portion of the property for a specific purpose, such as utility lines. Legal description. The precise location and boundaries of the property. Covenants. Restrictions on how the property can be used. Abstract of title. A summary document that details the property's legal history. Government grant. It is a document issued by a sovereign entity, such as the federal, state, or local government. A government grant is the core mechanism by which a land patent transfers original, supreme title of public land to private ownership. The patent document itself serves as the official, recorded evidence of this initial grant from the sovereign authority, federal or state government. Breakdown of the government grant in a land patent. The process and document, the patent, includes several key elements. 1. Sovereign authority and intent. Issuer, the government, federal or state, as the original owner of public domain land, issues the grant. Purpose. Historically, grants were used to encourage westward expansion, settlement, and development, e.g., through the Homestead Act of 1862, or as rewards for military service. Mechanism. The government, often via agencies like the General Land Office, acted as the grantor, essentially issuing a quitclaim of its interest in a specific parcel of land. 2. The grantee, recipient. Identification. The patent clearly names the individual or entity, e.g., a private citizen, a railroad company, a university, receiving the land. Eligibility. Recipients had to meet specific criteria set by the relevant act of Congress, such as residing on and improving the land or paying associated fees. 3. The land description. Specific identification. The patent contains a detailed legal description of the land's boundaries, often using meets and bounds or a specific survey description. This process required an official survey to precisely define the parcel. 4. Legal effect of the grant, highest form of title. The issuance of the patent grants the highest form of legal title, fee simple ownership, to the private entity, superior to any subsequent claims or deeds. Transfer into private domain. Once granted, the land is permanently transferred from public to private hands and becomes subject to local and state laws, including taxation. In perpetuity, the rights granted by the patent typically pass to the grantees, heirs, and assigns forever, establishing a permanent chain of ownership. Foundation for subsequent deeds. The land patent serves as the foundational document for all future ownership transfers, e.g., warranty deeds, quitclaim deeds, related to that parcel. In essence, the government grant, finalized and documented as a land patent, is the foundational act that brought a piece of land into the system of private property ownership in the United States. Historical context. Land patents were crucial for transferring public domain land to private citizens, encouraging settlement and development through programs like the Homestead Act of 1862. In U.S. history, land patents served as the primary mechanism for the government to transfer public land into private ownership, forming the foundation of the American system of property rights and facilitating westward expansion. Colonial origins. Feudal system shift. The American system departed from the European feudal system, where land ownership rested with the monarch. Early colonial governments began establishing formal registration systems to clarify property rights and encourage settlement, a process that included head rights systems offering land for bringing people into the colony. Post-Revolution. After the American Revolution, the new U.S. government confiscated land previously held by the British Crown. The need to raise revenue and manage vast newly acquired territories led to the development of a systematic land distribution policy. Foundational legislation, late 18th century, Land Ordinance of 1785. This key act established the Public Land Survey System, also known as the Rectangular Survey System, which provided for the orderly surveying and titling of public lands into townships and sections. This framework was essential for the legal description and sale of land. Northwest Ordinance of 1787. This ordinance provided the basis for territorial self-government and the process for admitting new states, linking land distribution to national growth and governance. General Land Office, GLO. Established in 1812, the GLO was the federal agency responsible for managing and dispersing public lands and maintaining records of all land patents issued. Westward expansion and settlement, 19th century. Purpose: land patents were crucial to the U.S. policy of westward expansion, encouraging settlement and development of the frontier. Acquisition process. Settlers typically applied for a parcel, which would be surveyed. After paying cash or credit and often meeting conditions such as residing on and improving the land, they would receive a patent, which was the final proof of government-recognized ownership. The Homestead Act of 1862. This landmark act granted millions of acres of land, effectively free of charge, to settlers who agreed to live on and cultivate the land for a period of time, leading to widespread issuance of patents. Legal significance. Highest form of title. A land patent represents the original grant of land from the sovereign government to a private individual or entity and is considered the highest form of legal title. Foundation of title chain. It is the first link in the chain of title for any piece of property and is the foundational document for all subsequent private ownership transfers, which are handled via deeds. Priority over subsequent laws. The rights conferred by a federal land patent are often said to take precedence over subsequent state laws or local regulations, a principle that has led to complex legal disputes, though courts have often struck down extremist claims made by some groups. Modern context. Land patents are generally no longer issued today for new private land acquisition, as most public land suitable for this purpose has already been distributed. However, they remain highly significant for historical and genealogical research. They offer insights into the lives of early settlers. Resolving disputes. Tracing property history back to the original patent can help clarify ownership or boundary disputes. Mineral rights. In some cases, the original land patent can be critical in determining who holds the rights to minerals beneath the land, as these rights may have been severed from surface rights over time. Foundation for future transactions. A land patent serves as the basis for all subsequent ownership transfers. Once patented, the land can be sold or inherited using a deed, but the patent is the original proof of title, according to Acre Value and U.S. Legal, Inc. The term foundation for future transactions for land patent does not correspond to a known legal process. A land patent is a legal document, the highest form of land title in the U.S., that conveys ownership of land directly from the government to an individual. The process for obtaining a land patent historically involved claiming public land, making improvements, and filing an application with the General Land Office, which would issue the patent after verification. Modern land patents are often issued for mineral rights and are administered by the Bureau of Land Management. Historical land patent process is claiming public land. An individual would claim a parcel of public land by filing entry papers with the General Land Office, GLO. Establishing a claim, the claimant had to provide evidence of ownership, including a description of the land and proof of improvements made, such as clearing or building. Verification. The GLO verified the claim and verified that the claimant had paid survey and other associated fees. Issuance of patent. The land was officially granted to the individual through a land patent, a document signed and sealed by the U.S. President, which transferred the rights to the individual and their heirs forever. Modern land patent process. Administering agency. The Bureau of Land Management, BLM, is the modern equivalent of the GLO and administers land patent records today. Purpose. Modern patents are often issued to protect mineral rights, which are separate from the surface rights of the land. Issuance. The BLM issues patents to landowners and absentee landowners for various purposes. Important considerations. Sovereign citizen movement. Some individuals and groups, particularly those associated with the sovereign citizen movement, have promoted incorrect and legally unsupported interpretations of land patents as a way to claim sovereignty and invalidate existing laws. Legal precedent. Courts have repeatedly rejected these sovereign citizen claims. Title and deeds. A land patent is different from a deed, which represents subsequent transfers of a property after the original patent has been issued. Modern relevance. Today, most land is already privately owned, so new land patents are rarely issued for previously unpatented land, though the document remains the ultimate proof of original title for existing patented properties. In modern property law, land patents serve primarily as the foundational documents for a property's chain of title, providing the original grant of land from the government to private ownership. While they represent the highest form of title, they do not grant landowners absolute sovereignty or exemption from modern laws, taxes, or regulations, contrary to some persistent misconceptions. Foundational and historical relevance. Root of title. Every private land claim in the U.S. traces its ownership history, chain of title, back to an original land patent or similar sovereign grant. Proof of original ownership. The patent serves as a permanent historical record, verifying that the land is no longer public domain and has been conveyed in fee simple to a private party. Historical research. They are valuable resources for historians, genealogists, and land researchers, offering insights into early settlement and land distribution patterns. Modern legal application and limitations. Establishing clear title. In rare cases, a historical land patent may be used in court to resolve complex or long-standing ownership disputes, particularly those involving unclear documentation or the original boundaries of properties, such as land that has become submerged by water. Mineral and drilling rights. Land patents sometimes specify the rights to minerals, or water on or under the property, which can be a key factor in real estate transactions and disputes over resource extraction rights. Transfer of ownership. Once land has been patented, ownership is transferred through standard legal instruments like warranty deeds or quitclaim deeds and must be recorded with local authorities. Not a shield against regulation. Courts have consistently rejected the claim that holding a land patent exempts a landowner from state and local laws, including property taxes. Patented land is subject to local property taxes once it is in private hands. Zoning and building codes. Land use regulations still apply. Eminent domain seizure. The land can still be subject to liens, other than those the owner agrees to via contract, and lawful seizure by the state or federal government under due process. Key misconceptions. A prevalent modern myth is that one can file a new land patent on existing private property to gain superior or allodial title, thereby avoiding taxes or government authority. Courts have ruled such self-serving declarations have no legal basis and do not create valid title. In essence, land patents provide the unassailable starting point for a property's title, but modern property law, deeds, and local regulations govern the ongoing rights and responsibilities of current landowners. The land patent specifies any usage restrictions, such as oil and mineral rights, roadways, ditches, and canals, that apply to the land. These restrictions are separate from state and local statutory regulations concerning property associated with the land, including zoning laws, building codes, and property taxes that pertain to both the land and any structures on it. Private property rights associated with land patents can be further negotiated based on the terms of private contracts. These rights, inherent in patented land, pass from one heir to another, from an heir to an assignee, or from an assignee to another assignee, and are immutable except through private agreements like a warranty deed or quitclaim deed. The legal framework governing a specific parcel of patented land is typically dictated by the congressional act or treaty through which it was obtained, or by the terms outlined in the patent itself. For instance, U.S. laws governing the land may be influenced by acts like the Homestead Act or reservations specified in the patent. Similarly, the Treaty of Guadalupe Hidalgo dictates jurisdictional provisions concerning extensive land areas in California and neighboring regions. When a territory agreed to enter the United States, an enabling act was agreed to as a condition precedent of statehood. The Enabling Act requires that all unappropriated lands, which are not yet privately owned, to be forever disclaimed by the territory and the people of the territory, and the title to ceded to the United States for its disposition. For example, the Enabling Act of the Washington Territory declares in part that the people inhabiting said proposed states do agree and declare that they forever disclaim all right and title to the unappropriated public lands lying within the boundaries thereof, and to all lands lying within said limits owned or held by any Indian or Indian tribes, and that until the title thereto shall have been extinguished by the United States, the same shall be and remain subject to the disposition of the United States. Once the people of the territory disclaimed their right and title to the land, the United States held it in trust until an individual established a claim, often by enhancing the homestead parcel over a specific period. Upon the submission of a valid claim, the United States General Land Office, now the Bureau of Land Management, verifies that the claimant has covered the survey expenses and made an additional deposit. Lastly, pursuant to the various land acts of Congress, the land is granted to the private owner by letters patent under the signature and seal of the U.S. President. Entities other than natural persons, such as trusts and corporations, are not eligible to acquire land patents unless specifically authorized by an act of the U.S. Congress. One instance of Congress granting land through patents to corporate entities is exemplified by the railroad grants issued under the Pacific Railroad Acts. These grants were provided to compensate railroad companies for constructing a transcontinental railroad spanning across America.